Present in the virtual courtroom, we have both parties along with their respective attorneys, Mr. Hess on behalf of the plaintiff, Mr. Crow on behalf of the defendant. We're here on actually both parties' objection to the referee recommendation and order in this matter. And I'll just tell the parties I spent significant amount of time reading all of the transcripts, reading the objections, the responses. So I don't want to rehash everything. If you just hit your highlights and your oral arguments, that would be appreciated. So, Mr. Hess.
Well, thank you, Your Honor. So for my objection to referee recommendation and order, as indicated, we do largely agree with it. The objection concerns how the parenting time is structured. There's some requests or there's some parenting time that's ordered for a weekend or even a day, and a fair amount of it, and that's just too much. I think both sides actually pointed this out, that there's that this places quite a burden on the parties and the kids with the travel and the exchanges. So we would request that the monthly weekends be cut down or eliminated. The holidays that are a day or so, let's see, Easter's 1 day, Mother's Day is 9 hours, and Juneteenth is 1 day. I mean, it doesn't really make a lot of sense to transport the kids across the country for a day or so. I mean, I understand the kids do need to see both parents, but I don't think that that's in the children's best interest, and it certainly places quite a burden on both sides with the transportation and expense. I would suggest that the defendant have a total of 4 weeks in the summer. I think that's appropriate considering all the circumstances. I think the exchange points need to be at the Grand Rapids airport up here, and the cell phone lot at the Pensacola airport in Florida. The defendant is able to give 3 weeks notice of her weekends. It doesn't specify how the transportation will be split. I'd suggest that each party is responsible for their own transportation when they're obtaining the child at the start of their own parenting time. That seems to make the most sense. There's already been some conflict about this. As I've indicated, there was a big problem last weekend with the parenting time. My client's mother, who obviously lives here in town, was going to transport the children back to Florida per the court order that is in effect. Defendant proceeded to cause all kinds of problems. I attached texts from her to my client, text between her and my client, text between her and my client's mother, a form that was signed during this 45-minute encounter with the police, where she claims to be bullied by having to follow the court order and give up the kids. So all of this is terribly unfortunate. She really seems to be overwhelmed with hostility and more concerned about creating drama and conflict than the best interest of the kids. Unfortunately, instead of the kids just simply being transported back to Florida Sunday night per the court order, they have to witness this huge 45-minute ordeal, the cops being involved. So I don't know, there's never been a court order that my client's mother cannot transport the kids or assist with transportation. This is their grandmother, not some stranger. this grandmother has always been highly involved in the children's lives. So the defendant's objections really don't make any sense at all. And kind of her militant approach with that really is in line with the a message that she sent to the school, which has been outlined in different pleadings recently, just highly inappropriate of what she sent to the school. Ms. Jada Jones is also saying through the FaceTime parenting time, which she's been exercising since the interim effect order went into effect, she is saying highly inappropriate things, blaming, saying that she's filing a motion, telling the children that they're going to be going back to Michigan. I don't think that's appropriate to tell the kids that. And she's telling the kids to blame their mother, Haley, for different things. So, I mean, my client allowed that, but this is really problematic, and it just goes to the overall course of conduct of the defendant. I think that your March 27 ex parte order was entirely appropriate, which overruled the March 21 ex parte order. We went through a full trial on this, and we proved the custody, the change of domicile. We proved it in the best interest of the children. I think that the defendant in her recent pleadings is giving slanted and deceptive versions of what occurred. But I will leave that to you. One additional problem on Sunday night at 7:00, because the court order says that on Wednesdays and Sundays, when defendant does not have the children in her care, that she gets the FaceTime or video contact with her kids. So she had the kids last weekend, Friday evening to Sunday evening. Finally, the kids were turned over to my client's mother for the transportation back to Florida. And then she's contacting my client, trying to FaceTime the kids, claiming that that's been ordered. So that really doesn't make any sense. That's not what the interim order says. She did have the kids in her care that day, but that's how the defendant is interpreting it, that even when she has the kids from Friday evening to Sunday evening, she's still entitled to her FaceTime on Sundays at 7 p.m. So, of course, I've never heard of anything like that, where somebody has their weekend parenting time and then at 7:00, they have more FaceTime parenting time. So that's really unfortunate. Again, it's just adding to the overall turmoil quite unnecessarily. I think that the larger part of the referee's orders were quite appropriate. But the parenting time does need to be, the short trips need to be minimized quite a bit, if not entirely eliminated. Ms. Jada Jones can have her 4 weeks in the summer. The court feels that's appropriate, and some other larger breaks. But that's our position, Your Honor. Thank you.
Hey, thank you. Mr. Crow.
Thank you, Your Honor. So I would like to, if I could, just directly address the issue with why we are before the court today, dealing with the both the ex parte applications, Your Honor, and also dealing with the objection that we filed. I will say, and I do not intend to be hyperbolic at all when I say this, I have never seen a recommendation depart so profoundly from a record. And I am not going to, and the court has had the opportunity to review the transcript, so I'm not going to go into great detail at this time, although I would respectfully ask the court for an opportunity to do that at our hearing. I would say, Your Honor, that the conclusions that were reached by the referee in this case are based upon conjecture and based upon information either not in the record or that was impeached comprehensively on the record. And I would suggest to the court that there are a significant amount of mistaken or misappropriated facts that were used to come to the conclusion by the referee in this case. And I say that with great respect. In addition to that, there are new facts that have come to light since the time of the issuance of the order that are germane and relevant to the best interest factors. It is my understanding now that Ms. Jones is going to be moving into, I think, her 7th or 8th residence over the last 2 years. She is again taking the children out of school where they are the new school that they have been pulled out of the Grand Rapids school, the Michigan school district, and now they've been put into a whole nother school in Florida. Now they're being taken out of that school into another school because there's another move. This is the 7th or 8th move that the children have had. We filed an ex parte application, Your Honor, after the referee's recommendation was issued. The court granted that ex parte application, preventing the children from leaving the jurisdiction until the court had an opportunity to hear this objection. Then a second ex parte application, which I don't think was procedurally sound for there to be a second ex parte application. Quite frankly, what the appropriate procedural step would have been to file an objection to our ex parte, but a second one was filed, and that ex parte somehow, I think with a different judge, vacated our initial ex parte. So now we have a situation, Your Honor, pending the disposition of our objection. We have a situation where we have 2 children who have an attachment disorder and an avoidance disorder, in which the witness provided by Ms. Haley Jones in this case testified on the record that it was not in their interest to make immediate changes, which the record demonstrates. We now have a situation where we have these 2 children who have now been ripped from Michigan, who have now been sent to Florida in the middle of a school year, where they have IEPs already set up in Michigan and where there are not IEPs set up in Florida because of this decision. And we have children who are now being completely set apart from Ms. Jones and the relationship that they had with Ms. Jones. And this the need for the instantaneous moving of the children from one jurisdiction to the next while school is going on is not something I have ever seen, Your Honor, in these proceedings. There is absolutely no basis for doing so. And the court was quite correct to issue the initial ex parte so that the court could have an opportunity to hear our objections in the case. Let's be very clear, Your Honor. In the referee's report, there are facts and there are inferences made by the court that are not sustainable by the record. There are the witnesses provided by Ms. Jones in this case were considerably impeached during the cross-examination portion of this hearing, in so much that they went back upon their initial recommendations that they made. I can think of the counselor as one in this case. This recommendation, Your Honor, is far afield from what happened at trial. And I'm not going to argue balls and strikes at this time, Your Honor, as it relates to what happened at the trial. But there is no reasonable basis for this order to be issued. More to that point, Your Honor, with this recommendation being issued, we have 2 children who are now suffering irreparable harm because of this recommendation, because of the fact that they are, and I believe that the recommendation is reckless in its scope, in that we are taking 2 children who have a psychological disorder, and this is not my client's testimony. This is the testimony of Ms. Haley Jones's witness.
Again, you're repeating yourself a little bit. I
don't
get
mean
that.
to,
So, okay.
And so
let me ask you this. You said there's new evidence that has arisen. That was evidence that was not available at the referee hearing, correct?
So this is it. Correct, Judge.
Okay. And that specifically references a move?
Well, it at this point now, and there was testimony during the course of the hearing, that Ms. Jones over the last 2 years, and Ms. Haley Jones, has moved somewhere, I believe, between 5 and 7 times over the last 2 years. Now the children, after this hurried relocation to Florida, now these 2 children were, I guess, supposed to go to one school district and go and live in one house. Now apparently there's another move afoot that the children in Florida are now going to go to another school district and have another home.
Okay, I don't want to argue the whole thing now.
Yes,
I
Judge.
just am trying to find where the parameters here, because the court is going to enforce the court rule. The court will set a hearing in this matter. The order remains in effect as it currently is in effect until the conclusion of the hearing, if in fact the court makes any changes. As I said, the court has read the transcript. The court is going to limit the review to those transcripts and on any evidence that was not available at the referee hearing, yes, any evidence that was not available at the referee hearing, the court will permit at this hearing. The court's not going to allow any evidence on findings of fact to which no objection was filed. And we'll find right now that the referee's finding was conclusive as to any facts to which no objection was filed. And we will let you know when that hearing is going to be. And
Yes,
as
Your
I said,
Honor.
it's going to be very narrow in scope.
So, Your Honor, just to clarify one point, if there are, and you'll forgive me if I'm putting too fine a point on it, but as it relates to the transcript and us being able to open that issue, we can certainly bring to the court's attention direct contradictions between what happened in the transcript and what happened in the recommendation. Is that also fair, Judge?
I would suggest that if you want to supplement your objection, that would be the place to do that.
Okay, Judge, but if it's already covered in the objection, that would be sufficient.
Yeah, sure.
Okay, thank you, Your
I'm
Honor.
essentially saying whatever's in the objection, the court will take notice of and consider. And if it's not in the objection, then it's conclusive.
Yes, Judge.
Okay. Any other questions?
No, Your Honor. Thank you.
So
Mr.
this
Hess?
is going to be a fairly limited evidentiary hearing? Is that where this
Yes,
is going?
the court is going to base the de novo on the record and the arguments that have already been submitted by both parties in writing, and any additional new evidence that was not available at the referee hearing is what the court is going to look at.
Okay.
All
Thank you,
right.
Judge.
Okay.
All
right.
In the meantime, there's no other changes to the current order. Is that?
Yes, it stays in place just as is.
So just to be clear, the court is, with the immediate relocation and the dueling ex parte applications, the court wishes the relocation to continue as it currently stands.
Yes. The current order of the court is the current order of the court.
Thank you, Your Honor.
All right. Thank you.
Thank you, Your Honor.
We're adjourned in the virtual courtroom. We have both parties as well as Daniel Hess, attorney for plaintiff, and Wayne Crow, attorney for defendant. We're here on both parties' objections to the referee recommendation regarding parenting time in this matter. Also present is Ms. Sines, who I understand will be called as a witness. Ms. Sines, we're going to put you back in the waiting room, but I wanted to admonish you that you should not be watching YouTube. The YouTube is this proceeding or receiving any communications regarding the testimony from anyone. Do you understand that?
I do.
Okay. So we will put you back in the waiting room and we will let you in when it's time for you to testify.
All right.
Thank you. And Ms. Van Noller, you may start the clock. And Mr. Crow, my understanding is that the parties have agreed that you will begin.
Yes, Your Honor. Thank you very much. And if it pleases the court, I'm going to begin with oral argument on this issue, if the court will allow.
Yes.
Okay. Good morning, Your Honor. Good morning, counsel. Good morning to the parties. We are here today on my client's de novo application before the court. And we are truly before the court because we have a decision that is seeking a record. That is what's happening in this case. A review of the referee's recommendation is replete with both factual errors, legal errors, and in addition to that, misstatements that are crucial to, I believe, a fair resolution of this case. Our objection starts as it relates to the facts and findings of this case, in which it begins in the first three sentences of this recommendation, is a error. Information not in the record, but just assumed by the referee, that there was a period of time in which Ms. Jones had, quote unquote, relocated to Wisconsin. This issue had been addressed during the course of our hearing. There is no evidence to suggest that there was any move to the state of Wisconsin, and that is one of the issues in which is used to determine what the established custodial environment in this case. The transcript itself does not demonstrate, the record does not demonstrate in any fashion that this move took place at all, but it's being used foundationally as a way to adjust the burden as it relates to the established custodial environment. Now, in addition to that, we have quite a few factual errors that have happened that occurred in the course of this recommendation. Now, number one, The entirety of this decision is, in my view, based upon three separate factors. It's based on, number one, the fact that my client made certain Facebook posts. Number two, regarding an incident that occurred outside of my client's apartment. And number three, an issue with my client sending an email to the principal, just a stern email. And if you look through the factors that the referee used to come to the conclusion in this case, you can see that essentially she based her entire decision on those three factors. Number one, as it relates to the quote unquote Facebook posts, as is in the record, Your Honor, my client is a social media influencer, and she stated on the record that these Facebook posts were not indicative of her actual behavior, and there was no testimony or no evidence whatsoever to suggest that it wasn't the case. No evidence put forth by my client saying that this did occur. No evidence put forth by Ms. Haley Jones indicating that any of these things occurred. Essentially, my client writes a few Facebook posts, and now we have two children who have been relocated out of the state of Michigan to the state of Florida. On that same note, Your Honor, what is a lot of hay is being made in the referee's recommendation regarding an incident that occurred outside of her apartment. Now, during the course of our hearing, we discussed this in great detail. There was testimony from my client. There was testimony from Ms. Haley Jones regarding what occurred. And there was no evidence to suggest that, first of all, that there was any tangential involvement between the parties. In addition to that, there was no evidence to suggest that my client had anything to do with the shootings. In fact, there were quite a few that the record indicated that the shooting didn't just affect my client's car, but affected quite a few other cars in the apartment building. And this issue, which, by the way, had appeared in front of Your Honor, and the court had come to the same conclusion that I think the referee should have come to in that situation, which was that essentially it was that this happened outside of an apartment building that my client was staying in for a few weeks until her house closed. And those that and an email that my client sent to a principal, which was not in any way inappropriate or obscene, but it was just stern. If you look through the entire decision made by referee Kessler in this case, that is the current that runs through this entire argument. Every single time in which the referee wishes to define against my client, she finds a way to reference those factors. And if you look at it, it runs throughout the entire case. But the record clearly does not indicate that these issues are of great substance. Now, what the record does indicate, and which is ignored to a fashion which I think is completely inappropriate, what is ignored is the conduct of Ms. Jones in this case. In fact, there is nothing more telling than what occurred in the factor as it relates to the legal residence, the factor involving the residence and the stability and the continuity of the respective families. We have a situation in this case in which there was testimony which was unrebutted that my client for the last nearly 2 years has been living in a residence which is completely reasonable, by all accounts, very, very nice. There was testimony regarding the amount of the multiple bedrooms that she had in the residence, that the children enjoy living there, that there is absolutely no issue to it, and that there's been stability and continuity throughout the entire process. Now, if you look on the other side of it, there is testimony not from my witness, not from Ms. Jones, but from Ms. Haley Jones regarding I believe the 6 or 7 different residences that she's lived in over the course of the last 2 or 3 years. In fact, it's my understanding that she just moved to another residence about 2 months ago. There is a complete dearth of stability, but instead of hearing about that in the referee's recommendation, which the record has a fulsome description of, instead of that, Your Honor, what we hear is we hear a discussion of a brief incident that occurred at a hotel, which has been dealt with on the record and which has been impeached on the record and shown not to be a factor of great import by any means. And then essentially we also have the issue regarding an email that my client sent to her teacher. And and they have a very good relationship, but my client is a very direct person. And if truth be told, it is the affect of my client. It is the fact that she is a very direct person and the fact that she cares deeply for her children and will do whatever she needs to do for her children that I think has cost her quite a bit in this case. I think her affect is in the fact that the way she presents can sometimes come across as gruff, but that does not mean in any fashion that my client has not done a profoundly good job as the parent of these children. Now, this decision has dramatically changed the course of these two children's lives. And if the court will, in review of the transcript, I am sure that the court has come across the testimony of the counselor in this case, who, first of all, came before the court and testified that these two children suffer from a disorder, a detachment disorder, in which changes to the lives of the children, immediate quick changes to the lives of the children, are detrimental to their well-being. And essentially, what the court did in this case is that they took the recommendation, and by detachment, I mean an adjustment disorder. I'm sorry, Your Honor. They have an adjustment disorder, and there was testimony by the counselor in this case, and the counselor testified that she did not believe that a sudden change to the lives of the children would be advantageous when I asked her during cross-examination. In fact, she indicated that the exact diagnosis and the exact disorder that these two children have in that adjusting to situations, that these types of changes would not be in the children's interest. And then what decision do we get in this case, Your Honor? And this is, again, testimony by Ms. Haley Jones's witness, not mine. What happens in the case then? We have an order that not at the end of a school year, but immediately disrupts the entirety of the children's lives. We take the children from a school that they have been excelling in, and that was testimony that was on the record by Ms. Haley Jones, that Ms. Haley Jones in a school in which she chose, that the children were doing very well, that they had a counselor, that there was an IEP set up for the children. All of that is in the record, Your Honor, and that they were doing very, very well. Then we have testimony from the counselor saying that that due to their adjustment disorder and the nature of their disorder, these sudden changes are not in the children's interest. So what do we get as a recommendation in this case? Immediate change, immediate dislocation, immediate relocation of the children from this state to the other side of the country. And why is this relocation occurring? Is this relocation occurring because of some great opportunity that the children have or Ms. Haley Jones has? No, it's going because she has an on-again, off-again relationship with her boyfriend. And the court has found that is a sound enough basis. In fact, they even had language in the referee's recommendation about how this would call for a family reunion between the boyfriend and their children. And that we have a situation where we have a boyfriend who testified about, in which there was testimony that during the course of the time the children were in their care, that he made false statements about my client, that he pretended to be their father, that there were allegations of domestic violence that had come up, all affecting this gentleman. And despite all of this, for some reason, even though the record is replete with any information showing the importance, the soundness of the relationship between this new boyfriend or this boyfriend and Ms. Jones, this is the basis for completely disrupting the lives of these children and to taking them out of a situation in which they could have an active relationship with one of their parents. I have to say, and I am not intending to be hyperbolic at all, I have never seen a decision that, in my view, is so devoid of a rational, so devoid of any connection between a record and a decision in my practice. I have never seen a situation in which the most incidental incidents are raised raised for one client, and profoundly disturbing incidents are downplayed on the other side of this case. And I am certainly not asking the court to take my word on it. A simple review, in my estimation, of the transcript and of what happened in this case, you can see, in my view, you can see one case, Ms. Jones's case, Ms. Jones's testimony, the cross-examination of Ms. Jones, and the evidence presented by Ms. Jones in this case. You can take a look at that, and you can compare it to the information and the evidence that was supplied by Ms. Jones in this case. And in my view, I think that this is a rather one-sided application, a one-sided issue, I believe. And I think that the record itself and the transcript itself certainly calls for that, Your Honor. That will complete my opening statement, Your Honor. And at this point, I'm ready to call a witness if the court will allow.
All right, please do.
At this time, I will call Ms. Jones. And I will remind Ms. Jones we have a very limited period of time. And so I would ask her to kind of keep her answers short and to the point if she could. So Ms. Jones.
Hold on, I have to swear her in.
Let's do that. Yes, Your Honor. Thank you.
Would you, Mr. Crow?
So, Ms. Jones, since the time of that this order was issued, do you harbor any concerns about what has been occurring with your children?
Yes.
Could you please tell the court what's been happening?
Abuse, domestic violence, relocating to homes that are not healthy, starting over in schools where they struggle with making
I'm
friends.
going to
And
object. The witness is not testifying from any personal knowledge. I don't know where she's making the statement from.
Well, she's testified for about 2 sentences now, Judge. I think that she will be explaining what the basis of information is. I'm sorry, Judge.
Perhaps you want to lay a foundation first.
That's fine. So, Ms. Jones, how long have the children now been primarily living in Florida for?
since April,
Okay, April of this year, correct?
yes.
And how often have you seen the children since April of this year?
Every opportunity that I can.
And what does that mean, pursuant to the order?
The order says that I can see them 1 week in a month.
Okay, and so the children, so to be clear, under this order, the children now have to travel from Florida to Michigan, is that right? Every month?
Correct,
Okay, and so they're flying every month now, is that right?
correct.
And you heard me say a few moments ago that that the children had been diagnosed with an adjustment disorder, isn't that correct?
Correct.
Okay, and do you believe, without indicating what the children have said, do you believe that that this move is in their best interest right now?
No,
And tell me why you feel that way.
because they are getting me eliminated as a parent. I don't get to see them or talk to them as much as I did before this order went into place.
Has this been disruptive to your relationship between you and the children?
Yes,
Now, you've had an opportunity to review the referee recommendation and order, correct?
correct.
That was issued by Referee Kessler.
Yes,
And as it relates to, well, as one of the reasons in which was given in this recommendation was the relationship between the boyfriend of Ms. Haley and Ms. Haley. Do you believe that Mr. Mello is a good influence on the lives of these children?
no.
And why do you say that?
There's been a couple CPS cases involving Mr. Mello. I've never seen him show up to anything that regarded the children as far as.
I'm going to object.
That's in the record, Your Honor.
Okay, I'm not aware of any substantiation, certainly.
That's not what my client testified to, though, Mr. Hess.
And I'll just remind everyone, this is very limited, and I am confining everyone to the court rule about evidence that was not available at the time of the hearing before the referee.
Yes, right. And my client is just stating what's in the record. Okay, you may continue your testimony.
I've never seen him show up to any of the sporting or dance classes or any events the whole period that they were in a relationship together. Mr. Mello has been absent for 14 months prior to this.
I'm going to object. I mean, this testimony all seems to be going back. It doesn't seem to be confined to the last 3 months or so.
So, Your Honor, my client is.
Again, it really, what the testimony should be about is evidence that was not available at the time of the referee hearing, and it's not in the record. If it's in the record, I will see it. So
Yes,
we don't
Judge.
need to
Okay.
move on
Well, we
that.
can move on. Okay,
Okay.
and since the time of the order, what concerns have you had regarding Mr. Mello?
Domestic violence.
And tell me what is it that your understanding of that is?
Just the other day, police showed up at my house stating that they were investigating abuse with Mr. Mello and Tobias.
Okay, and as it relates to other issues, have there been other issues that have been of consequence and that happened during that period
In the last
in the last 3 months?
Yes, it's just that I don't know if I can say it because it might be hearsay. So
Well, don't say what anybody else has said. Are there
Okay.
any other concerns that you have?
just living in the home with Mr. Mello and the domestic violence, the children.
I'm going to object to this. I mean, the witness is not.
I'm going to move on. I'm going to move on.
Personal knowledge. I mean,
Okay, I'm going to withdraw the question just so I don't waste my time, with long objections. I'll move on, withdraw the question. So have there been issues with the visitation and the pickup and drop off since the time in which this order has come into place?
Yes.
Okay, tell me what's happened.
The police have been called to my house. Haley's mother has driven by several times, parked in front of my house, showed up unannounced several times after I've asked not to do that. The pickup drop off has been a lot of argumentation about if she's supposed to come to my house to pick up the kids or not. The order says that she's supposed to, but she was under the impression that she wasn't at one point in time. It's just become a lot for the children to always be there, and then the police are showing up and it scares them, and it's just a lot of that going on.
Was there a recent issue that occurred between you and Miss Haley Jones and her mother showing up at your house?
Yes, actually on July 15th at drop off, Haley Jones pulls up to let the kids out of the car, and then her mom shows up in another separate vehicle, just lurking around the neighborhood, and I didn't understand what was going on.
So there were two cars that came to the
Yes.
visitation, and so what actually occurred? Was any interaction between you and the mother?
No, because we have a no trespass, no contact order with the mother due to her doing this several incidents before.
Okay, so there's already an order in place saying the mother cannot trespass on your property.
Right.
Okay, understood. And how has this this order affected, in your estimation, affected your relationship with the kids?
It affected greatly. I went from seeing the children 2 to 4 times a week, picking them up from school every Monday, every Thursday, taking them to basketball practice, taking them to gymnastics, dance class, baseball. I mean, I'm the parent who enrolled the children in all the extracurricular activities and made sure that they kept up with going to practice, going to the games, and instilling that into them. And now I'm going from seeing them 2 to 4 times a week personally in person to 1 time a month on a weekend where we're spending most of our days traveling the whole weekend.
Okay. And do you think it's, in your opinion, do you think it's healthy for the children to have to travel every month by airplane from Florida to Michigan?
No.
That seems like a lot of traveling, wouldn't you say?
Yes.
Okay. And we're in, okay, I'm going to reclaim my time, I guess, at this point. I'll stop and I will allow Mr. Hess. Now, and this is on Mr. Hess's time now, the cross-examination?
Correct.
Okay,
Mr.
thank you.
Hess.
Okay, no cross-examination.
Any other witnesses, Mr. Crowe?
I call Ms. Haley Jones.
Right.
Good day, Ms. Jones. So, and I'm going to get right to the point because time is limited. Ms. Jones, since you've lived in the state of Florida, have you already moved residences again?
We did move.
Okay. And so, and where did you move compared to where you were previously living?
About a mile down the road.
Okay. And so this is, so in the last 3 years, so how many moves is this now that you've had?
I'm gonna object. I mean, this goes back to, yeah, I guess this is already part of the record. The prior moves. You can certainly ask about what's happened after the referee findings.
I mean, Your Honor, I don't think it's.
I don't know how it's relevant. I mean, yeah, I think that
Again, I think Mr. Crowe can use his time however he wishes, but again, what's in the record is in the record, so.
Okay.
So how many moves is this marked now in the last 3 years?
Number, I don't.
It's quite a few though at this point, right? Okay. Has there been, to your knowledge, has there been any CPS investigation or whatever the equivalent in Florida is of Mr. Mello during the last few months, if you know?
There has been a recent one, yes.
And what was that regarding?
I never spoke to a CPS worker at all. No one's called me or talked to me at all. But I know that a DCF worker has been to our house.
Okay. And in addition to that, has there been, how has the, Ms. Jones spoke just a moment ago regarding a pickup and drop off in which you brought your mother along with you. Is that right?
Correct.
Do you think that is a good way to kind of keep the volume down between you and Ms. Jones, since you do obviously have a very difficult relationship, to bring folks in which there's a trespass against to bring to the visitation? Do you think that was a wise thing to do?
It was either that or a peace officer, and I try to keep the police out of it. So I asked my mom to follow to make sure that we were safe. Being that we're at Jada's residence, it's not a public place. We don't have video cameras going. And my mom parked across the street in front of Jada's neighbor's house, never got out of the car, never opened the window.
Okay, but you are aware of the fact that Ms. Jones and your mother have had a difficult history. Is that correct? Are you not aware of that?
Within the past few months, I am aware of that. Although
Okay.
my mom did not trespass any property whatsoever, didn't make communication, didn't harass, didn't get out of the car.
And yet, at the same point, you had no concern about bringing her to this visitation when obviously you guys have a lot of difficulty dealing with each other. Is that fair to say?
Can you restate that again?
That it didn't cause you any concern to bring your mother to that visit, did it?
No.
No. Okay. Your Honor, can I just take 1 minute with my client, if I may? And if I could keep my time
Yes.
on that, just hold on. Thank you. Thank you, Your Honor. Ma'am, how often do you leave the children alone with Mr. Milo?
I mean, not too often. In the summer, more often than not.
Okay. And have you ever seen Mr. Milo?
Home.
I'm sorry, I didn't know you. Please finish your statement.
So no, he works during the time of about end of July, beginning of August, all the way through like May. So when he's home, I might be able to run to the grocery store by myself. But other than that, I pretty much have all the kids.
And have you ever
Not
seen
too
Mr.
often.
Okay, and have you ever seen Mr. Milo strike any of the kids?
I have not.
Have you ever seen him hit the back of the heads of one of the children?
No.
Okay.
He will yell at them, but he does not hit them.
Tell me about, so when you say that he will yell at the children, what do you mean by that?
Like he will yell at them, he'll discipline, he'll raise their voice if they're not listening. But he's not physically abusive to them.
Okay, and and that's fine with you? You think it's appropriate for your boyfriend to be disciplining the children?
100%.
Really?
If they need to be told something and I'm not around to be able to do that, he should be able to let them know that they are doing something and that they are not supposed to be doing. Like they should be held accountable for their actions, even if I'm not in the room.
And they should be held accountable to your boyfriend, is that right?
I don't know what you mean by that.
I mean, it should be your boyfriend who they're held accountable to. Is that your testimony?
I don't know what that means.
Okay, well, you just said a moment ago that they should listen to your boyfriend and do what your boyfriend says. Is that right?
Absolutely. He's an adult. They should be respected.
Objection. This is argumentative.
Your Honor, I think it's completely appropriate for me to inquire regarding the relationship between the boyfriend and the children. If the main reason
Objection overruled.
Thank you. And so, okay. So if would you allow Mr. Milo to discipline your kids in a corporal fashion?
In a what?
Corporal fashion. Would you be okay with them hitting your kids?
No.
No. Okay. And so, and you testified a moment ago, you don't know what the subject of the CPS investigation that's currently pending is about. Is that right?
I do not. I have not spoken to a DCF worker in Florida.
I mean, have you spoken with Mr. Mello about it?
I have, but he did not give me the details. He said that they would be visiting our house on Tuesday when I got back to speak to me.
I mean, I'm not asking you to testify to what he told you, but that's a little odd that he would come to you and say, I have a CPS report, and you didn't find out what it was about, isn't it?
Objection. Asked and answered.
I didn't ask that question, Judge.
Say it again.
Overruled.
Isn't it a little bit odd that Mr. Milo comes to you and says, I have a CPS case against him, and you don't inquire about what that CPS case is about?
I think this
objection
this calls for here's
Your Honor, certainly counsel has a right to has a right to have his objections noted by the court, but I have a limited amount of time, Your Honor, and the court has made a decision on the previous objection. If filibustering my time, Your Honor, I don't think is appropriate.
I'll overrule the objection.
Ma'am?
No, I didn't ask.
Okay. How have the children's health been since they've been in your care?
I mean, fine. Tegan has had stomach pain over like a course of 2 weeks, and then Tobias had strep throat.
Okay, is there a skin disorder that one of the children have?
Yes.
Tell me about that.
It's a viral wart. It's called molluscum, and I guess it's very common among children. Tegan's the only one who has it. Our other 3 kids in the house do not have it. She's being treated for it currently, but it is not affecting the way she's able to eat, drink, play. I mean, she is healthy other than the skin.
And is she under the care of a physician right now?
She is, yeah. She has a dermatologist for that.
Okay, I understand. Okay. And for the okay, and no, I'm going to hold on. I'm going to reserve my time for any rebuttal, Your Honor, and for cross-examination. Thank you, Your Honor.
Mr. Hess.
Can you explain the move from the one residence to another in Florida?
Yeah, when Lucas and the kids had moved down prior to us, they were in a rental home. After that year had ended for our rental agreement, the owners of that home decided to put that house up for sale. We did not want to buy that house, and they were not renewing the rental agreement for us. So we decided to find another rental home close to the area. Like I said, it's about a mile down the road. And we went from a 4-bedroom house to a 5-bedroom house. So now all the kids have their own space and we're actually very happy with that home.
Okay. How are how do you believe the children are adjusting to Florida in general?
I believe that they are adjusting well. They're doing great in school. I think they're doing good.
Okay. The kids have had a few absences from school, is that right?
Yes.
Can you explain those absences?
Yeah. There was a May 10 date that they were absent. They were absent for travel from Florida to Michigan on that day. So they did not go to school that day. They flew out early. On that Monday, May 13, they were absent. That was due to weather. We had a storm coming in with 80-mile-per-hour winds and there was tornado warnings. That previous weekend, we had a storm that took our fence out and destroyed our backyard. I decided that I didn't want them to be at home or at school during that storm. So I decided to keep them at home under my care so that they were not stuck at school in a tornado or a storm where I was not able to go pick them up. And then what was the next date? The 15th? Do you have that?
Was there an illness?
There was another day where Tegan stayed home due to stomach pain, and I actually had gone around to like the med center, hospital, trying to just figure out where to take her for care. But I was not able to get her seen before the kids had to be picked up from school at 2:15. Therefore, she was not seen that day, but I did not get a doctor's note because we never actually saw a physician. And then the last absence, I think it was the 23rd, the kids had an appointment in the morning for establishing care with a pediatrician down there. And then Tobias was checked in late at 11:30 and Tegan stayed with me.
Okay. And those are the absences. So the kids' first day of school, do you recall what day that was in Florida?
April 8th.
Okay, so those are the absences since April 8th.
Yeah.
Okay. Was there some difficulty regarding the April 21 Sunday, April 21 weekend where the kids came up to Michigan to visit Jada?
Yeah.
Can you explain how that happened?
Yeah, so Jada flew into Pensacola to grab the kids during that month for her weekend. And then my mom, I asked her if she would fly the kids back because she wanted to come and visit us for some time and stay with us and see our new home and stuff. And so I told my mom to go pick up the kids from Jada's residence, and then she was flying them out that next morning. But there was a huge discrepancy with letting the kids go with my mom.
So let me stop you there. So prior to April 21, wasn't your mom part of an exchange with the kids at Jada's house on April 5?
Yes.
And were there any issues on April 5?
No.
Were there issues with your mom exchanging the kids prior to April 5, 2024?
Not that I'm aware of.
Okay. All right. And so then on April 21, you notified Jada that your mom would be picking up the kids that evening at 6.
Yes,
Correct?
on our family wizard, yeah.
All right. And what was Jada's response?
She basically said that she wasn't handing over the kids because I was not there. And the order, she said, stated that it's between me and her, and that's the exchange. Therefore, my mom is not able to pick up the kids for me in my place.
Okay. Did your mom attempt to get the children?
Yeah, she did.
Okay. And did she have you on speakerphone while this occurred?
Yes.
Okay. And were the police called to facilitate the transfer?
Yes, I had a peace officer come just to make sure it was a smooth transaction.
Okay, all right. And from what you could hear, was Jada agreeing to turn over the kids?
No.
Okay. And eventually the officer persuaded the transfer? Is that-
Yes.
Okay. And it took about how long for that to take place?
About 45 minutes.
Okay. All right. When you say the kids are doing well in school, what exactly do you mean by that?
Tobias was my main concern moving because of his transition and adjustment disorder. But he had done really well from the first day of school until the last day of school. In his IEP meeting that we had, in which Jada was present as well, he had met 100% of his IEP goals, and they stated that the IEP.
Objection to what either what the IEP or what the representative said, if they're not here to testify, Your Honor.
Sustained. It's clearly hearsay.
Okay.
Okay, so I could say that, based on Tobias's IEP, he met all of his IEP goals from
Objection.
the start to the finish.
Objection, Your Honor.
I don't know how
All
to
right,
say.
all right. I'll rephrase the question. Were there any issues or problems with Tobias meeting his IEP goals?
No,
Okay. And what about academically for Tegan and Tobias? I mean, how's that going?
well, very well.
Okay. And the kids were in counseling. Both kids had a separate counselor at the time of the move this spring. Is that right?
Yes.
And did either of those counselors present any concerns or reservations about you moving to Florida with the kids?
Objection. That will certainly, whatever the next statement that the counselor said is going to certainly be hearsay, Your Honor. If that's the question, is what do they say? It's going to be hearsay, Judge.
Mr. Hess.
Well, I think I can ask my client, I'll refer, whether she's aware of any concerns that the counselors had about the
Unless
move.
that basis is not hearsay, Your Honor, I would say that it's still, end run hearsay.
I'll sustain.
Has there ever been any CPS substantiation against you or Lucas that you're aware of?
No, never.
Do you or Lucas have any criminal record ever?
No, we don't.
Okay. You've had to deal with some friend of the court complaints by Jada recently?
That is correct.
Okay, what was the basis of those complaints?
That I did not answer the 7 p.m. FaceTime calls on the weekends that she has had the kids.
Okay. Do you think that that's a reasonable interpretation of the order, that as soon as the kids are with her all day, but then she gets the FaceTime communication at 7 p.m. as well?
Objection calls for a legal conclusion. She's asking he's asking the witness to interpret an FOC evaluation, Your Honor, from a legal perspective.
I'm asking my client if it's a reasonable interpretation of the current order.
A reasonable interpretation calls for a legal conclusion, Your Honor. And
She can give her opinion.
She can give her lay opinion.
Yes, Your Honor.
In my opinion, that's not how I interpreted it. I don't believe that the kids should be on FaceTime shortly after they get home while they're adjusting to getting home. It just doesn't make sense to me, so I have not enforced it, and that's not how I read it, because I think that if they're with her that day, then they don't have to FaceTime.
Okay. What do you think about the parenting time of 1 weekend a month in Michigan? Is that reasonable in your mind, or should something be changed or modified with regard to that?
I think it's excessive. Like Jada said, it's not in the best interest for the kids. And I think that is exhausting for the children. It's exhausting for us to travel that quick there and back.
Okay. And in terms of the exchanges, where do you think the exchanges should take place?
I think they should be right at the airport.
Okay,
I think that's the easiest spot.
okay. And does it make sense for each of you to be responsible for the travel when you're going to get the children for your own time?
I believe so, yes.
Okay, I don't have anything further.
Just one moment, Your Honor. Okay, so ma'am, you testified a moment ago regarding the amount of absences. How many absences have they had in total thus far since they relocated to Florida in the middle of the school year?
Tegan 4, Tobias 3.5.
Okay, and how many latenesses do they have?
I don't know. You'd have to look at the paper that you guys submitted.
Okay. Has it been would you say that they have been late a significant amount of times?
I wouldn't say a significant amount of times, no.
How would you describe it?
I would say that they're late at school the same amount of time here than they are there.
Okay. And in addition to that, did you tell your child to call the police on my client at any time?
I did.
You instructed your child to call the police on Miss Jada Jones, is that correct?
If they were not brought back to us,
So,
then I told her that she needs to find help because Jada has kidnapped them and taken them and hidden them and hotel hopped with them before, which is already in the record. So I guess that doesn't need to be said. Although I have told Tegan that if she doesn't come back when she knows she's supposed to, then she needs to seek help. Because I will also be trying to find them as well.
okay, so you think that my client is going to Lutron, you think it is appropriate to tell your children they should call the police on my client, is that right?
100%. If they are not being brought back home and they are being withheld and hidden, 100% every time.
Okay. Should they also call the police if they're hit by your boyfriend?
They are not hit by my boyfriend.
But if they were being physically abused at your home, they should also call the police.
Objection, speculative.
I mean, Your Honor, it's in response to the last answer, Your Honor. It's a follow-up question.
I'll allow the question.
I don't know.
You don't know? I'm sorry, you don't know the answer to that question? If your kids are being hit by your boyfriend, should they call the police?
If they're being abused, sure.
But
But
being
not
hit is
abused.
okay by your boyfriend, though. Is that right?
Huh?
Is it okay? So it's okay for them to be hit by your boyfriend, just not abused. Is that right?
Objection, there's been no testimony.
That's a
My-
follow-up to her question, Your Honor.
I said if they were being abused, although they
Okay. Okay, but then my follow-up question to you, if there is any if there's a situation where Mr. Milo is striking your children, would you consider that abuse?
I would.
Okay. So I just want to be clear, and if they were being abused, you'd want the kids to call the police, right? That's the only point I'm getting to.
Yes.
Okay, gotcha. Just as it relates to having the incident that you discussed regarding the pickup at the airport, it seems that you're quite content having your mom be very much involved with the pickup and drop-offs with the kids, despite your mom and my client having a very difficult relationship. Isn't that right?
I am okay with my mom being involved with pickups and drop-offs. If I need her, then I am okay with that.
But you know that your mom and Miss Jones have a difficult relationship, right?
Objection, counsel's misstating testimony. My client testified that prior to April 21, they didn't have any difficulties with exchanges at all.
Okay. I mean, I'm just asking whether she's aware of any difficulties that they've had.
Yeah. I am.
Okay. And yet, despite their difficulties, you're still using her as to assist in pickup and drop off, right?
Not necessarily assist. She did not assist in this last drop off. She was just there behind me as like a safety net, I guess you could say.
Okay. Do you have any desire? Do you have any desire to co-parent with my client?
Beyond just for what is necessary for the kids, no.
Well, I mean, I would assume by co-parenting it would be regarding the kids. Do you think that that working as a reasonable joint custodian, legal custodian with my client, do you think that's an important goal?
I believe it is an important goal, yes.
And do you think your conduct has indicated that you are interested in doing that?
Absolutely.
Okay. And I mean, so when you took Tegan to the ER recently, did you contact my client and let her know?
I did not know.
Okay. And this is like a long string of you not complying with your joint legal custodial responsibilities.
Objection, argumentative.
It's not argumentative, Your Honor. It's cross-examination.
Because Tegan did not have a PCP yet, I went.
Allow it. You need to wait for me to rule on the objection.
Thank you, Your Honor. And there have been quite a few incidents, and this is all in the record ad nauseum, times in which you did not comply with being a reasonable joint custodian with my client. Is it the plan that you're going to continue this conduct?
No,
So what happened recently when the child was taken to the ER, you didn't call my client? That's indicative of you turning over a new leaf. Is that right?
what was the last part you said?
Indicative of you turning over a new leaf.
I don't know what that means.
Indicative of you changing your behavior.
No, I mean, she was never seen.
Right. All right. I'm going to, may I inquire about how much time I have left? I'm sorry, Your Honor, you're muted.
Ms. Van Oler.
34 minutes has been used.
Thank you very much. I have no further questions, Your Honor. Thank you.
Mr. Hess.
Has Jada made it easy to co-parent with her?
Never.
I don't have anything further.
Thank you. Any additional witnesses?
For me, I would call Miss Nora Sines. I don't know if Mr. Crow has finished his case.
That was my question for Mr. Crow.
Oh, I'm sorry, Judge. Forgive me. One moment, Your Honor. I have nothing further this time, Your Honor. I would like to reserve for a closing statement, if I may.
All right, that's fine. And Mr. Hess.
I would like to call Miss Nora Sines.
Thank you.
Miss Sines, how are you acquainted with the parties?
Haley is my daughter.
Okay.
Sure.
And you were involved in an exchange of the children on April 5 of this year. Is that right?
Yes.
Okay. And the exchange was from who to who?
From Jada to myself, picking up the kids for Haley
Okay. And where did that exchange occur?
at Jada's home.
Okay. Were there any issues with the exchange?
No,
Okay. Prior to April 5, did you have issues exchanging the kids with Jada?
no,
On April 21 of this year, you were involved with an exchange of the children. Is that right?
yes.
Okay. And I guess please explain what happened.
Haley asked me to pick up the children in her absence, and I was going
So
to.
just to clarify, Haley was in Florida. Is that right?
Yeah.
And,
Yeah.
and the idea was that, correct me if I'm wrong, you were going to fly the children back to Florida,
Yes,
right, at the end of Jada's weekend, correct?
yes, that is correct.
Okay, all right. And what happened on April 21?
Haley had called me earlier in the day to let me know that she had been in contact with Jada and that she was going to ask for a sheriff to be there for a peaceful transfer, as she expressed to me that Jada was not willing to let me have the kids to take them with me, and that she had expected that Haley should be there to get them for the transfer.
Okay. So you appeared at Jada's residence,
Yes, that's correct.
and about what time did you get there?
I want to say that I sent her a text at about 5:55, letting her know that I had arrived and that I knew I was early and that I would just wait street side.
Okay, so where did you park?
I parked across the street from the home.
Okay, and did you exit the car?
No, I did not.
Okay, and did the police show up?
Yes, he did.
Okay, and did the police go to the door then at Jada's house?
Yes, he did.
Okay, And what did you see? What did you observe at that point?
I observed that Jada met the police officer at the door and they had a conversation of asking, he told me he was going to ask.
Objection.
And
Sustained. Ms. Signs, you can't say what other people told you. Mr. Hess.
okay. And did the kids come right out of the house?
Not immediately.
Okay. And was there yelling involved at some point with Jada? Was there yelling involved at some point with Jada?
There were multiple episodes where her voice was escalated.
Okay. All right. And did you see the children?
Not initially. At one point, they did step out on the porch and then went back into the home.
Okay. And if they were anywhere near the door, would they have heard the yelling that was going on?
Yes.
Objection to what the children did or did not hear.
Perhaps you want to clarify your question, Mr. Hess.
Were the children out on the porch while there was yelling by Jada?
No.
Do you know where the children were at that point when there was yelling by Jada?
I do not know where the children were in the house.
Okay. Was it loud enough? You don't have to tell me what she said, but was the yelling loud enough that you could hear what Jada was saying?
I could hear most of what she was saying from across the street with my window open when she was using an escalated voice or a louder voice.
Okay. Eventually, were you able to get the children?
Yes.
Okay. The next day, did Jada send you a text?
Yes.
And that's the text that starts out by saying, Nora, this is your final chance, something to that effect.
I believe it said, "This is your last warning."
Okay. All right. All right. And she forced you to sign something before you took the kids?
She gave me a paper to sign before she would release the kids.
Okay. And you wrote a note on it also?
Yes, because I didn't agree with what was on it.
Okay. All right. And had Jada ever had you sign anything at any prior exchange that you've done with her?
No.
Okay. But this was the first exchange that had occurred once the kids had actually moved to Florida, correct?
Yes.
Okay. And about how long did it take while you were sitting there to actually obtain the kids?
I would say approximately an hour.
Okay. You saw some activity with the blinds at the house, is that right?
I did when I first arrived.
What did you see? What activity did you see with the blinds?
It appeared as though someone was peeking through the blinds. There was a lower peeking.
Object to the relevance of this question, Your Honor, of somebody peeking through is there some connection to anything involved with this case?
I'm showing that the children were close by and essentially witnessed this whole ordeal.
And by the ordeal, we're talking about which ordeal are we talking about? Where your client brought the sheriff to the house? Is that the ordeal?
the ordeal where your client refused to turn over the kids, was yelling and screaming, and the whole thing went on for an hour.
All right,
That ordeal.
I don't, again, Mr. Huss could use his time however he'd like, so
Ms.
I
Ryan.
will.
Thank you.
So I'll ask you again, Nora, what was going on with the blinds?
It appeared as though someone was peeking through them because they were separated.
Okay.
It looked like they were separated at a lower level and at a higher level.
Okay. And did it appear that the lower level was the children?
The lower level appeared as though it could be someone like the children, their height.
How many other people were there that you saw?
I saw Jada's mom and dad.
Okay. Was Jada's wife there as well?
I did.
I didn't hear that answer.
I'm sorry. I did see her wife. Yes.
Okay. What were the kids doing when they eventually came out of the house towards your car?
At that time, when they were finally coming out to the car, they walked down the driveway while Jada was having an interaction with the sheriff's department at her front doorstep. And I immediately got out of the car to stop them from crossing the street.
Okay. Who took the kids across the street?
They were escorted. They were told to wait and to be escorted by the sheriff.
Okay. But what were the kids doing? What was their reaction to all this?
When they came out, they seemed a little upset.
Were they crying?
Not initially, but they had tears welling up in their eyes. Tobias more than Tegan.
Okay. And then I guess last Monday you witnessed an exchange of the kids as well?
That would be correct.
Okay. And where did you park then?
I parked in front of the neighbor's house next to Jada's house, across the street behind where Haley was.
Did you stay in your car?
I did.
Okay. And what did you believe that your purpose there was?
Haley asked me to be there to help support her because she didn't feel safe.
Okay. Is there a no trespass or no contact order against you with regard to Jada or her property that you're aware of?
Yes, there is.
What is it? Is it trespass or what is it?
It's just a no trespass order.
Okay.
I was told by the
It's not a no
sheriff's department.
contact order.
No.
Okay. And this is just what the cop verbally told you?
Yes, after the July 15th, when Haley returned the kids, a call was made to the sheriff's department. She received the call while I was there. He asked her what happened and asked if I had stepped out of my car or been on her property or made any direct contact with her. At that time, I asked if there was more than a no trespass order against me, and he said not that he was aware of, that there was just the no trespass, no contact.
Okay. All right. But the officer did not believe that you violated any no trespass order.
Based on the information we provided him, he told us
Objection.
that
Sustained.
When Jada was yelling with the cop, did she say something specific to the cop with regard to the law that you heard?
she asked, I heard her say to him, "Do you know the law?"
Objection. What the officer said to Ms. Jones.
It's what Miss Jada Jones said.
I'm sorry. Is she testifying to what Ms. Jones said? Okay. Withdrawn.
Nora, on July 15, when the kids were walking out the driveway, did you hear Jada yelling then?
My window was closed. I could not hear her exact words, but she was yelling in front of her yard and raising her arm as if she was angry, pointing in my direction.
Okay, and the children, did they see this?
The objection has
Yes.
been answered, Your Honor. I think we've covered this ground like 3 or 4 times now. Again, with whether the children were present, whether they
Well,
saw.
we're on to July 15 now. I think we talked about April 21.
I'll allow the question.
Thank you, Your Honor.
The children heard on July 15, the children heard Jada yelling.
Yes.
Objection to what the children heard or did not hear.
Did
Sustained.
Jada's yelling seem to have an effect on the children from what you observed?
Yes.
Okay, what effect from what you observed?
I saw them walk up to the driveway. They stopped immediately and had a look of fear on their face.
Objection to a look of fear, Your Honor. Certainly she can describe facial gesticulations took place, but for her to characterize it in some fashion, I don't think that would be, Your Honor, appropriate.
Mr. Hess.
I think she can give her lay opinion, but if I need more detail, I can get it.
Well, she can't give lay opinion regarding what was in the minds of the children, whether it be fear or, she can describe what they look like.
I'll sustain. I think we need some more specifics.
Okay, what was the mannerism? You've seen people that were in fear before in your life. Is that right, Nora?
Yes.
Okay, and how do people act when they're in fear?
Objection. Relevance to, I'm sure she's not here to testify regarding her experiences.
Okay, all right. What were the kids doing?
The kids were walking to the driveway. When the yelling started, I looked directly at them and they stopped immediately in their tracks, did not move anymore, turned their bodies facing in Jada's direction. They both raised their heads, no smiles on their faces, and their eyes were wide open and did not move.
Okay. All right, thank you. That's all I have.
And so after that occurred, ma'am, they went and they gave Miss Jones a hug. Isn't that correct? A hug goodbye?
I did not observe that.
Sorry. Did they give the hold on one moment. All right. Well, let's actually start with the incident that occurred at my client's residence. Now, do you happen to know when the sheriff was actually called? Was it at 6 o'clock or was it several hours earlier that the sheriff was called?
I believe the sheriff was called prior to the pickup.
Now, in fact, it wasn't prior to the pickup. It was prior to the pickup, but it was 5 hours earlier, right? About 1 o'clock that the sheriff was actually called. Isn't that right?
I do not know the answer to that question.
Okay, but let's be clear. This was not a circumstance or a situation in which you arrived to pick up the kids and there was an incident and then the sheriff was called. This was a plan of action, was it not? That the sheriff was going to be present during the pickup and drop off, correct?
It was a peaceful transfer.
Okay, but a peaceful transfer doesn't usually have the sheriff have to come out for a peaceful transfer parenting time. Isn't that fair to say?
I do not know the answer to that question.
Okay, but but would you agree that it's a little bit provocative that during the first, I believe this is this is the April 15th, I believe one of the first times in which the parenting time exchange took place pursuant to this order, that the initial instinct was let's get the police involved before the pickup and drop off even took place. Isn't that fair to say?
No.
No, so why were the police, won't that only escalate a situation between two parties who have had a difficult time with each other? In your opinion?
There was no incidents that took place on April 15th.
All right. Well, just to be clear, so first of all, the pickup and drop off time was supposed to be 6 o'clock, correct?
For what occurrence?
Or the occurrence that occurred at my client's residence.
I'm asking for clarification of the date.
I believe that was July 15th. The July 15th incident that occurred at my client's residence when the drop off was taking place.
Haley dropped them off after their vacation time with her. Yes.
Okay. Okay. And so essentially, whose idea was it to have the sheriff called?
There was no sheriff on the July 15th drop off.
But on the April 15th is what I'm referring to. Whose idea was it to call the sheriff?
It was Haley's.
Okay, gotcha. And in your lay experience, generally speaking, having the police immediately involved with something like that, does that tend to de-escalate situations in your opinion?
Objection asked and answered. It's
It's a
speculative,
different question,
argumentative.
and she's testified, and I think it's a reasonable question in cross-examination, whether she believes that would de-escalate. If the entire point of this is to try to demonstrate that it was Miss Jones was at fault for this, and the other side is calling the police, sending
All right, I don't need an argument on
Yes,
objection, so I will allow the question.
Okay. Do you think that generally calling the police before with two parties who have a contentious relationship tends to de-escalate a situation?
I do not know their relationship.
Okay. And so as it relates to the second incident, so just to be clear, you and Ms. Jones comes, you come over to the residence to do the pickup initially on the first incident, and you find out that there is you said a trespassing, that you have been trespassed off the property. Is that right?
There is a no trespass order that was filed when I was on my way back from Florida.
Okay.
After
And so
the
then at that point, the decision was, and please correct me if my facts are wrong here. Then the decision is that you're going to be the one who's then going to interact with Miss Jones at the airport. Is that right?
airport for
No,
what occurred.
no, forgive me. As it relates to the pickup, the next pickup, you're the one who comes and you come to the residence, and you with your daughter, you elect to come with your daughter back to the residence. Is that right?
July 15th. Yes, I followed my daughter in my own car.
And this is after you've known that you've been trespassed by Miss Jones, correct?
Yes, that is correct.
Okay. But the decision still was, I think listen, I know that I've just been trespassed off this property, but I think it's a really good idea that I send my mom, who's been trespassed, let's have her come to this, because that's going to help us keep the situation calm and under control. Was that the thinking?
No, that was not.
Okay, but I mean, knowing you've been trespassed, you still went, didn't you?
Yes, I did.
Okay, all right. And so, do you think that maybe in hindsight, since these parties clearly have a very difficult relationship, that maybe we shouldn't take steps that are going to inflame the situation?
Objection, argumentative.
It's cross-examination. I'm asking her opinion. She's given her opinion quite a bit in this case.
I think it's permissible.
So, I mean, don't you think that it might be a good idea to try to de-escalate the situation rather than try to make this as stressful a situation as possible for everyone involved, including the kids?
I believe providing my daughter's safety was my reason for being there.
How are you going to provide your child with safety by being there?
If an incident were to have taken place, I could have called the police, or I was told by the sheriff's department that the no trespass order would be void if I interacted in that incident, if I felt that Haley was at harm.
This is a really odd way to help keep the peace between parties, in my opinion. I have nothing further for this witness, Your Honor. Thank you.
Mr. Hess.
So Nora, with regard to April 21, it's your understanding that the police were called because Jada had already told Haley that she wasn't giving you the kids, correct?
That is correct.
And it was only after the officer's involvement for approximately an hour that she finally did relinquish the kids, correct?
Correct.
So the officer arrived at about 6 o'clock that day, correct?
6 or shortly thereafter.
Okay. So the officer was there for nearly a full hour.
Correct.
Okay. Did you believe you were being provocative in some way by staying in your car and hanging back down the street? With regard to July 15.
I don't believe I was making myself exposed, and I was staying out of the way, and I kept my window rolled up, and I did not have any interactions, nor did I go anywhere on the property.
Okay. Thank you. That's all I have.
Mr. Crow.
One moment, Your Honor. And what we haven't heard is why wasn't Haley present for this pickup and drop off? For the initial one, for the April pickup and drop off? Why were you there and not Haley?
For the April 21st, Haley asked me to be there in her absence.
And why was she absent?
She was in Florida.
Okay, and so she just elected not to come and pick up the kids herself.
You would have to ask Haley that.
All right. Well, she didn't give you a reason why she wasn't going to be there.
She asked me to pick them up. They're my grandchildren. It gave me an opportunity to spend time with them.
Okay, but there was no follow-up question at all. I mean, why are you wouldn't that be a normal follow-up question? You didn't ask why it is that she wasn't going to be present for her kids?
No, I was very excited to be able to pick them up so that I could spend time with them.
Okay. All right. I have nothing further. Thank you.
Mr. Hess.
Nora, it's expensive to travel from Florida. Is that right?
That is correct.
Did you believe that there should be any issue with the grandma providing some of the transportation?
Objection to form.
Did you believe there would be any problem with yourself as the grandmother who has done many exchanges in the past? Did you believe there would be an issue on April 21 with you doing the exchange?
No.
Okay, thank you. That's all I have.
Mr. Crow.
I have nothing further with this witness.
All right, thank you. May she be excused?
Yes.
Mr. Crow.
I'm sorry, Your Honor.
May she be excused?
Yes, Your Honor. Thank you.
All right. Thank you very much, Ms. Sines. You can leave.
Thank you.
All right, Mr. Hess.
I don't have any other witnesses. The only other thing I plan to do was make a closing argument.
All right. Since you went first, Mr. Crow.
Yes, Your Honor.
Did you want to make a closing argument?
Oh, yeah. No, I did, Your Honor. Would you like me to go first?
Yeah, yes. I just thought because you went first.
Oh, that's fine. I didn't know that
Presentation.
Mr. Hess was going to go first. No problem. I'd be happy to.
Okay.
All right. And how much time do I have remaining, Your Honor?
Ms. Van Oler. Go ahead and make your argument, Mr. Crow.
You can feel free to cut me off if I go over time, Judge. Thank you.
All right.
So, Your Honor, we've heard, so from Mr. Hess's side in this case, I shouldn't say Mr. Hess, forgive me, Ms. Haley Jones's side in this case, we've heard now sort of a real focus on these two issues that occurred after the time in which this order was issued. It's my understanding that there is currently an FOC case as relates to these issues. And so, in as much as I think that there may be some relevance to issues that have happened during the pickup and drop off, it's certainly not the focus of my case, Your Honor. And I don't think that as it relates to the de novo application we filed, which is regarding the blatant insufficiency and quite frankly, in my view, a very wrong-headed referee recommendation. My case is certainly not centered around these two issues. And I don't necessarily, other than the fact that they are illustrative of the fact that this parenting time schedule is incredibly problematic and is creating difficulty between the parties. I think that there is an FOC case that's currently pending. And I think that there is great disagreement regarding what occurred during these incidents and what occurred during these issues. And it seems to me that it is indicative of the incredibly difficult relationship that these two parties have, and the fact that they are certainly not doing a good job working together. And it's certainly my client's position that Ms. Jones, by her own testimony even today, and by her testimony on the record during the hearing, has continuously violated the order as it relates to being an appropriate joint legal custodian with my client. I mean, it is replete with testimony in the transcript regarding issues of her not choosing schools, not being informed regarding medical appointments. And even today, we've heard testimony that the child went to the emergency room and my client wasn't contacted. But I think the overreaching issue, Your Honor, is the fact that the referee recommendation and hearing is, in my view, does not have a basis in the record. Yeah, in my view, the basis for this decision is based purely on my client's affect and is not based upon the actual facts that were presented in the record. There is a great deal in the record that demonstrates, and we heard a little bit about it today, that Ms. Jones has been incredibly inconsistent and unstable over the last few years. Had we gotten an answer to the question today as it relates to the amount of times in which she has now moved over the last 2 or 3 years, I think we're getting close to 7, 8, or 9, the amount of times in which she's actually moved over the 3 years. There has been no stability in these children's lives with the exception of my client, which is what makes this referee's recommendation so outside of, in my view, so outside of what was contained in the record, as I stated in my opening statement today. The bottom line is that we have an incredibly inconsistent plaintiff in this case, Ms. Haley Jones, and we have a situation that we have a relocation that was granted based upon of a relationship she has with her boyfriend. The meager testimony and the meager record regarding Mr. Milo, the testimony basically says that he has a job working at a college coaching football. And they've been dating for a relatively short time, Your Honor, considering that the referee granted this application. And right now, although, and I'm sure that without question, once the CPS case bears fruit, if there's any basis to it, I'm sure that we're going to have a whole nother custody case based upon that, based upon now potential violence that is happening in their residence. And so we have a situation where we have Mr. Milo who testified very briefly, and the testimony was basically his job and how much he was earning, and didn't have much by way of explanation about essentially the allegations that were put forth regarding domestic violence. Didn't have much of a discussion about his relationship with the children. This decision is essentially crediting Mr. Milo with essentially being Ms. Jones's husband of 10 years. They have an on-again, off-again relationship, is what the record indicates, in which there was a period of time, even in the last 18 months before the hearing, in which they had been broken up for several months. There was some testimony that would suggest that. They suggested for a lesser period, but there was testimony that they had even been broken up for several months of time. Now, that did not stop this referee's recommendation from taking these children out of the place where they have lived consistently and moving them all the way to Florida while having a disorder that specifically speaks to not changing their environment and not changing their situation. Now, other than, testimony that is self-serving by Ms. Jones regarding how the children are doing in school, there's no evidence, any evidence been presented regarding how the children have been doing. In addition to that, you have a situation where now we're in the summer. It will be quite easy at this point if the court did grant our application and return the children back to the school that they have been consistently going to, that the children, that would be, I think, less of an adjustment than having the children continue this path of in the middle of a school year being taken out of their school situation. And if I just may make a brief comment on that point, I have to tell you, regardless of the way the court views in totality this case, I think it is incredibly unusual. We have 2 kids who have an IED and have essentially a disorder that indicates that and this is again testimony by their witness, that essentially has a disorder that indicates that there should not be fast and rapid change in their lives. That's their disorder. And so what does this recommendation do? Immediately rips them out of their counselor, their school, their entire situation, and sends them 1,000 miles south. It is the jurisprudence in that decision, Your Honor, makes no sense. According to this record, there's no emergency. There was no great reason for this to happen, to disrupt the children's lives, but it still happened. In fact, this court, I believe, rightfully granted an ex parte, which the court then reversed. But the court did initially grant an ex parte restricting that because it's such an unusual decision by the court. And what I would say, Your Honor, with respect, certainly, what I would say is that this recommendation is so far afield from the way in which these cases are decided, in which you have evidence, you have testimony that so clearly has a one-sided view of this case. You have a woman who has a boyfriend She moves around constantly. There are allegations that are put on the record, which she admitted that the children ingested prescription drugs or prescription drug while in her care. And the court bending over backwards, Your Honor, in my opinion, to grant, to take the smallest of issues against my client, turning them into mountains, and taking the largest of issues from Ms. Haley Jones and turning them into molehills. And again, as I said from the beginning, I believe, respectfully, I believe this referee is a decision in search of a record. I think that the court knew where they were going with this case. And I think that what they did is that they try to find anything that you could make a tangential connection with. And again, I don't ask for the court to take me at my word in my representation of my client. I think the transcript is clear. I think that if you look at the witness testimony, there is very little in this other than Facebook posts and a crime that happened near my client that occurred, very little at all to meet the standard necessary to completely change and alter these children's lives, to totally deprive my client of getting to be a real parent. Now she's got a weekend a month when she used to see the kids 4 times a week. And why? Because of a Facebook post? Because of an issue that happened at her apartment, which, by the way, this court, Your Honor, and this honorable court, when receiving an ex parte, did not grant further relief on it and said, hey, listen, I think you should probably move out of that apartment. And she did, to a beautiful home. And so even the court discredited that at the time in which that occurred. And so now that is being used as a basis to completely change the lives of 2 kids who have psychiatric guidance in which it should not be changed rapidly, to totally deprive my client of getting to be an active parent in these children's lives. And the basis for that are Facebook posts and an allegation that this court said did not rise to the level of any great significance. And that's it, Judge, to be very clear, other than a misstatement of fact indicating that my child had relocated to Wisconsin. No evidence, by the way, of that in the record whatsoever. That actually
2 minutes.
2 minutes. Thank you, Judge. No evidence. No evidence that actually occurred. I honestly do not know what the basis of that determination. But basically, what the referee's recommendation says is that my client hasn't been involved because she, quote, moved to Wisconsin, though that never happened, and there was no evidence presented of any great note that suggested that actually happened. But regardless, we're going to use that as a basis to come to this conclusion. That's number one. Number two, a couple of Facebook posts in which she's a social media influencer, which she gets paid to actually do that, to do social media posts. And this would be the first time, in my opinion, in which we are going to be changing where the children live because of a social media post. But in any case, and thirdly, about an issue that took place in her apartment building or in the hotel in which she was just staying until her beautiful new home was ready to go. As soon as that home was ready to go, she immediately moved into that home and has been living in there since. And there's been no testimony to suggest that home isn't anything but a great suburban enclave for these kids, and that she's been there ever since. The facts are on one side of this case, and the recommendation is on this case. It is so far afield from any record, any record that actually was presented before the court. There are, as I have highlighted during the course of my closing, Your Honor, there are quite a few factual inaccuracies or things that are either exaggerated or downplayed to such a degree that it really goes beyond a credibility determination. It really goes beyond the court, the referee coming to a conclusion regarding, whether I'm going to weigh this or weigh that. What it really comes down to, Judge, is that this, as I said, is a decision in search of a record. There was no question in this case what this decision was going to be. The only question was how the court. Okay, I'm just closing up, Judge.
All right.
So the only thing I was going to say is that the only thing in suspense was how the referee was going to get there. I have nothing further, Your Honor. Thank you.
Thank you. Mr. Hess.
Your Honor, if I could have about a 3-minute break, I'd appreciate it.
All right, you have the time. Go ahead.
Thank you, Your Honor. All right, so I'm ready if the court's ready then.
Yes, please.
Okay, all right, thank you. So, Your Honor, I think my client's case was actually quite simple and certainly supported by the record. Generally speaking, if you have someone that has 13 out of 14 overnights as a regular schedule, and that's what was agreed upon through the consent judgment of divorce, and they have a solid plan to move out of state that makes a lot of sense and is supported by the factors that the court would look at concerning change of domicile, then typically someone would be able to move. I mean, that's exactly what happened. I mean, Miss Jada had about 3 hours of parenting time on Mondays and Thursdays, and she had a 30-hour period on alternate weekends from noon on Saturday to 6 p.m. on Sunday. That was her parenting time for years. My client testified as to that she actually had, for a considerable period of time, far less parenting time than that. And I think it's totally inaccurate to say that she never moved to Wisconsin. I mean, her own exhibit that she turned in from the trial, it was exhibit I think it was the first exhibit. Her post said that she had moved to Wisconsin. So here we go. So May 18, 2021, and this is about 2 months after their judgment of divorce entered. Oh, I forgot to tell y'all, as of last week, I no longer live in Michigan. Cheers. So I don't understand where she's claiming that she never moved to Wisconsin. She certainly did. They're downplaying the significance of this incredibly aggressive email to the school. This is, and that was our exhibit A for the trial. I think it was incredibly aggressive. It's cited by the referee, appropriately so. There were a number of there's a number of concerns that my client had about Miss Jada, on top of her what should be a fairly simple case to move. I said, as I indicated, based on the limited parenting time that Jada had, and my client's overall plan to move, the capacity to improve the children's life. Mr. Mello testified to all that. To say that the record was barren is completely ridiculous. I wouldn't agree with that at all. As the counselor that testified in the trial indicated, the kids have always had stability with my client. If you look at the friend of the court report, which was entered as an exhibit in the last trial, Jada has been in and out of the children's lives. They've not had stability with her. It's not true that Jada is 100% responsible for all extracurricular activities. My client has certainly been a part of that as well. There were credibility issues with Jada as well. I think that the court appropriately found that my client should be able to move. My client did put her life on hold while this trial went on for nearly a year. My client explained all of her moves during the trial. Now this move in Florida occurred because the rental that they were in was being sold. They didn't have a choice. It's either buy the rental or move a mile away to another rental. They moved to a bigger house where each of the children have their own room. It's now a 5-bedroom house. So I don't know how they can say that there's anything inappropriate about that. The children are adjusting well. They're doing well in school. So I think to upset these children's lives yet again, after a mountain of evidence was put forth in the trial, they were allowed to move. I think it would really be unfortunate for these kids if they were sent back yet again. Miss Jada's entire case is that she doesn't like the move. She doesn't like it. We get it. And she, I don't think that, I think the law and the facts fully support this move. Jada continues to be difficult. There's numerous testimony about how difficult she is This continues to be the case when she makes an issue out of nothing. Real simple. Grandma's coming to get the kids just like she's done many times in the past. The only difference is this is now the first exchange since the children have moved to Florida. So Jada goes berserk, says that the grandmother is not going to be able to get the kids, that for some reason Jada says mom herself has to come up from Florida to get the kids. That's not what the court order indicates. That's not how anybody else operates. I mean, there's been never any restriction against the grandmother being part of the exchanges. It's just that Jada went berserk, and she did it in front of her kids. It was really unfortunate for them. With regard to the July 15 exchange, Nora hung back. She was there to witness in case anything went badly. But she was not there to cause any problems, didn't cause any problems, hung back. There again, it's Jada's reaction to everything. That's the problem. So I think if Your Honor looks at all the exhibits as well as the transcript from the initial case, I think it's more than clear that the referee's decision was not based on 3 items. It was based on a mountain of evidence, almost all of which says that these children should have been allowed to move. They were allowed to move, and things are going fine. They bring out these mysterious allegations against Mr. Mello. He's never had any criminal record or CPS substantiation. Neither has my client. I mean, these are just red herrings that are being thrown out there. We know how difficult Jada is. She's making an issue out of FaceTime when the order says that she doesn't get it when the kids are in her care that day. Nevertheless, she's turning over the kids at 6 o'clock or so and demanding FaceTime at 7. I mean, this is just harassment. I think the overall weight of the evidence is that the referee decision should be upheld. I think it's offensive to say that this longtime referee made her decision beforehand. I think she looked very carefully at all of the evidence and made an excellent, detailed decision. We did ask for some modifications, but I'll also indicate that the police report, which is not objected to for this hearing, our Exhibit 1 is part of the record. The police report indicates that Jada continued to yell and act in an unruly manner. He eventually released the 2 children to Haley's mother. So I think if Your Honor looks at that police report, you'll get a more accurate version than what Jada indicated as to what's going on. Our Exhibit 2 is in evidence. This is Jada's very aggressive email or message to Nora. The parties reached a stipulation in order for our Exhibit 3 as to a May 12 exchange, but I think it's appropriate that there be some modification to the court order. I think once every 2 months would be better than neither party likes once a month on the transfers. It should be once every 2 months. I think half the summer to each would be fair. Let's do the exchanges at the airport. The parties have always had a public exchange. It's probably not or at least that's been the court order for quite a while, probably not a great idea to do exchanges at anyone's house. We would ask that as I've indicated in my brief for today, that once the defendant has provided the receipt for or provided her notice of 3 weeks to have her weekend, that she provide the receipt for the flight so my client can purchase the return flight. The exhibits from the initial trial, there's all kinds of pro-marijuana exhibits. One where Jada's driving a boat. I think the referee found that that's not appropriate, that she's got this very public marijuana habit. for our other exhibit for today, Exhibit 4, which again is not objected to as part of the evidence. You can see Jada, she sent it to my client on April 21, that her position that even though my client was in Florida, somehow she's got to come all the way back to Michigan to do this exchange. Again, that just doesn't make any sense at all. It's simply Jada being incredibly difficult. My client does the best she can, but this is what my client has to deal with. So we would ask that the referee decision be upheld with the modifications that I've asked for in my evidentiary hearing brief for today. I'd also ask, Your Honor, that you look at my written closing argument and rebuttal closing argument from the initial trial. I think the law, the facts, the details all carefully laid out there, and certainly supported by the evidence and the record. Thank you, Your Honor.
Thank you. I'm going to take this under advisement and I will get an opinion out as soon as I can.
All right, thank you.